Welcome to Legally Speaking with Attorney Antoinette Osbourne. This program is for information purposes only. If you need legal advice, you can contact me, Antoinette Osbourne, at 718 502 9137. That's 718 502 9137. The office focuses on divorce, immigration, bankruptcy, real estate, and estate matters. We also do eviction proceedings. There is a second office in Jamaica, West Indies, that focuses on legal representation if you are seeking to buy or sell a property, or if you're looking to wrap up an estate. Now, this morning, I wanted to get into a recent law that has passed in New York that affects landlords. It's going to make it more difficult for you to evict tenants. Now, the only way you can get back, if you are a landlord in New York City, the only way you can actually get back your place is if your tenant has returned the key or if a marshal has evicted. So there is no thing as self-help where your tenant is not paying you, so you can just go in, and because as a landlord, you know the crosses that you face where the tenant is not paying you. You are responsible to provide heat, hot water, unless you have created a separate unit and you have in fact have your separate heating system. You're providing that heat, you are providing that hot water. And when a tenant is not paying you, it really becomes burdensome, right? Bear with me one sec while I try to turn on this light. Right? Can I say I have to get the lighting right? Woo. All right. So this new statute, which it's going to be so horrible for landlords. It's going to be like, it's going to be so hard for you to evict a tenant if you fall within this ambit of a house that is your landlord, that you're subject to, the good cause for eviction. So gone are the days where we just simply have our 30, 60, or 90-day notice, depending on the time period that the tenant is in your premises. That if you are in New York City, this is mandatory for you. So if you're in New York City and your property falls within this, you're a landlord that falls within this, you are stuck with this. It is going to be so ridiculously hard for you if you fall with this. And even if you don't fall within it, it's such an invasion of privacy for you. And we're just going to get into that, right? So remember, if you're a landlord, your tenant had better giving you back the key, or you got a judgment of possession through housing court, right? You don't have this. You have not really evicted your tenant. We don't have self-help in New York. And I'll tell you this is not the South. If you live in Kings County, so if you're in Brooklyn and you're filing your cases, Brooklyn on average is taking 5 months, after you file, to give you a court date. This is a dire crisis we are in New York City. Morning sunshine, this is a dire crisis that we are now in. So as landlords, get prepared, right? Because now New York has now enacted this good cause for eviction. You are just not able to evict like that. So you need now a reason to evict in New York. And I want you to kind of understand the seriousness of this. You can't just simply if your tenant is not in a lease. Back in the day, you just give like a 30-day notice if the tenant is in your premises for less than a year. If the tenant is in the premises between 1 to 2 years, or less than 2 years, sorry, you're looking to give a 60-day notice. And if the tenant is in your premises over 2 years, you have to give a 90-day notice. So, I mean, landlords were crying when this occurred, but no literal, what we call bawling is going to start now. So we want to get into the reasons that causes you, or that enables you now to evict the tenant. It gets serious for landlords. And we have a serious housing crisis going on. And this statute is not going to make it any easier if you are subject to this statute. And even if you're not even subject to the statute, we're going to get into later one of the ramifications that you must disclose now when you are not subject. It's called the good cause eviction statute. New law that came in, right? And it applies to all eviction cases that have been filed after April 20th of this year. So you have filed your case after April 20th this year. You are now subject to this law. All right, so let's get into it, right? Let's get it. All right, so one of the good cause is if your tenant has not paid rent, right? But that in itself is not the end all of it, because the question is, if the tenant has not paid rent, is your rent reasonable? So the fact that your tenant has not paid the rent, that's not good enough, because you can, if you're subject to this new statute, right, then your rent has to be reasonable. If your rent is unreasonable, and we're going to get into the whole aspect of unreasonable rent later, you can't evict. That's how serious it is for you. If your rent is unreasonable, as a landlord, this is going to be a defense for the tenant. And guess what? They are going to be able to dismiss your case. Yeah, so it's serious now. So let's hope whatever rent you have charged, it is in fact reasonable, because pursuant to this statute, if your rent is unreasonable, your case is going to get dismissed. So I'm hoping you'd have another basis to evict. Otherwise, you're stuck. Yeah. Thank your governor for signing this. Yeah. All right. So if the tenant has violated a substantial obligation of the tenancy, then this is a reason for you to be able to evict. Or let's say if they violated your rules and regulations, right? And if you're just joining us, welcome. I know I have not been on for a while. I'm getting into the new statute, which is the good cause for eviction statute. It took effect April 20th this year. And my personal opinion, if you are subject to this, it's going to be a nightmare for you to evict a tenant, right? Because gone are the simple days of just giving your termination notice. You don't need a reason, right? Your governor signed this. It came into effect April 20th. And we're now just getting into the reason, what constitutes good cause to evict a tenant. All right. So we went through if the tenant is not paying rent, but it has to be a reasonable rent. If the tenant has violated a substantial term in your lease, or they're not really adhering to the rules that you've made for the premises. Now we want to get in if the tenant has committed a nuisance. I think this whole nuisance filing on the basis of nuisance, right? Like it has to be like an ongoing nuisance. This is like a joke, because once the tenant has cured the nuisance, guess what? That's the end of the case. And sadly, the tenant just goes back and starts again. It's ridiculous. All right, now, if you are subject to this, right? Good cause. You need it now. You need now a good cause to evict. So if you are in fact now subject to this, one of the good cause that you can show is that you got a vacate order from the city. People are gonna get so frustrated. They're gonna call in that city, that state, agency, right? To basically, they're gonna report themselves now. Because guess what? It's gonna be so hard for you if you are subject to this to get rid of a tenant, especially like basement tenants. I've had tenants in basements, they are absolutely horrible. What people are going to do, they're going to sacrifice your pocket, because if you are subject to having a basement tenant in your place, but then you're subject to this good cause eviction, and like you have no basis to get rid of the tenant, and you have like an illegal unit, some people are going to be backed into a wall, and because they have no basis to evict and they have an illegal tenant, they're just going to call the city on them so that they can get a vacate order. They pay the fine, do whatever penalties, fees, and they just start over. So how do I see it? This is also a good way for the city now to start making money. Yeah, because if you're subject to this statute, it's literally going to be hard for you, because you have to have a good cause to evict the tenant. All right, now for the tenants who have, I take the stance that basically the whole premises belong to them. They're unreasonably refusing to give you access. If that is the case, this now constitutes a good cause to evict. But remember, you're still subject to serving your notice, and dependent on the time that the tenant actually has resided in the premises. Nobody's looking at the length of your lease or that your lease has expired. It goes back to the time the tenant has resided in the premises. So what is this going to force you to do? Remember, you are now going into a court of law. The burden is gonna be on you to show that the tenant has unreasonably refused to provide you access. So now you had better start putting this in writing, because word of mouth don't hold water. You just do like a conversation. The question is, who is the judge going to believe? So to protect yourself, you better start seeking access via a written form of communication. So it's either you're going to be texting, you are going to be emailing, or you are going to be sending via certified mail. One of the dangers though, when you're sending via certified mail, and if they have not picked up the mail, yeah, the issue is they have not had the notice, right? So text message will be great for iPhone users. You can see when they actually read the message. So you text the message, you let them know that, look, I need access to the apartment, and I'm going to encourage you to put a reason, right? So you need access, possibly you need access for repairs, right? Possibly you need to check, like their apartment is the only way you have access to your boiler, right? You want to basically attend to the boiler, maintain it. My thing is give your date, give your time, also give the reason, right? So do your salutations and put their names in it, like, good morning, Mary. On October 17th at 2:30 p.m., I would like access to the apartment to attend, to get access so that I can fix the boiler, or I need to conduct the repairs, or I need to check for a leak, right? Protect yourself. because it's going to be, it's getting rough for you as landlords. All right. If the premises is owner occupied, that's another basis, right? Oh, hold on 1 second, because I think I hear the kettle. Okay, we are back. All right. So when you have your owner occupied use, right? Now, the whole basis of this is quote unquote, right? To give the landlord a way to get back the place. But in reality, it's making it difficult. So we want to look at owner occupied use. And you're going to see when they bring these statutes, the main aim is quote unquote, give the landlord a viable option so that they can be able to evict if these circumstances arises, and to protect the tenants from being unreasonably evicted. But I'm going to show you now how these statutes don't really help, right? It's nearly like when they had changed the rules under Como for, I guess, the home health aides, because home health aides were working for 1 week straight and they weren't getting their overtime, right? So they're like, oh, after 40 hours, you have to pay overtime. So guess what the agencies did to them? Instead of them, especially when you live in and you live far and you're going to the job and you really just want to stay on, stack your money, guess what? Now the agencies, in order to protect themselves from suit, reduce their days from 7 to 4 days. So who did this really help? You know, you're trying to help, but then it's taking away. And I'm going to show you how. If the owner needs the apartment for their own personal use or they need it for a stated family member, but the tenant is 65 years old or older, this is not gonna be a reason. This is not one of the good cause to evict. So you know what's going to happen? When landlords are now renting their apartments, even though age discrimination, right, is a protected class, they're going to find a way now to try and avoid these category of people. So who is this really help? Unless a tenant is already in the apartment, then that helps. But for new seniors who are looking at apartments, the fact that I may get stuck with you and I may need my place, but I can't evict you because you're 65 or older, now they're gonna start discriminating. So who does this really help? Yeah. All right. So who are the family members if you need? Family members that falls within the ambit of owner occupied. So we have here, of course, if you the landlord, that definitely falls. The spouse, the domestic partner, and if I stop live with these men and don't seek rings. Domestic partner, child, stepchild, parent, step parent, sibling, grandparent, grandchild, parent-in-law. This is a one time you really have to call for your mother-in-law. Your parent-in-law or your sibling-in-law. These are the family members who will in fact be able to benefit from the owner needs it for their own use, right? Now, however, in order to benefit for this, the home must be the primary residence of the owner. What? So just to get this, right? You want, let's say your daughter got married and you have a building which is not your primary residence, but probably your child is going through a hard time and you don't want your child on the street and you sure as hell don't want them back in your place as they have now vacated. But you want to put them somewhere because you don't want them on the street. But you don't live in that building. So you don't get the benefit of owner occupied. This is the complete madness that falls within the ambit of the good cause for eviction. Yeah, it's crazy, you know? And I just want you to understand, as the housing crisis gets worse here in New York City, because New York City has to follow this. If you are in the suburbs, it's a question as to whether or not, or outside of New York City, it depends on whether the housing court in your area decides to or your town or whatever decides to adopt this. Madness. Yeah, but this is something that you have to know if you are a landlord, and if you are a tenant, this falls as a defense for you, right? If the landlord, of course, plans to demolish the home, that's a good cause for eviction, all right? And where the landlord plans to take the home off the market, this is also a good cause. Or if the tenant fails to agree to reasonable changes, right, to the lease, if written notice is provided on that 30, 60, 90, depends on where you fall on, before the expiration of the current lease, and the tenant is not agreeing to the reasonable changes that you are seeking to put in the lease. Because remember now, once your tenant is in a lease and you're deciding that you're going to renew that lease, if the tenant now decides that they don't want to, they are, if you're sending out the lease and you have changes, and then the tenant decides that they don't like the terms of the lease, you have to make sure that you provided the appropriate notice, because that's now a defense. Good morning, Amarildo. That's not a defense. And this is where people are going to be forced to keep these tenants. All right, so remember, you're trying to increase the rent. The question is, what's a reasonable increase? And remember, this is mandatory for New York City, right? And for people who are outside New York City, you have to look to see whether or not they adopted it where you are. So let's look at what's a reasonable rent increase, right? So if you're just joining us, we're now focusing on the good cause of eviction. Gone are the days where you think you could have just evict the tenant like that. It does not work like that. If you are in New York City, this is so mandatory for you. Whether you like it or not, who cares? It's the law. You have to follow it. You don't follow it, your case gets dismissed. Guess what? The tenant in the place, cocking up them foot in your place, that's it. You are subject to this if you are in New York City, because this is a statewide law. You have to look whether or not where you reside, they have actually adopted this. So let's look at your rent increases, because this is something everybody wants to know, how far can I increase the rent, right? So this new statute creates what is called a local rent standard. Yeah. All right. And your local rent standard is based on inflation in your local area. So for every area, New York City, of course, has their own standard. You have to check what is the local inflation in your area. So the local rent standard now, right, is set every year at the rate of inflation plus 5%. but you can't increase the rent regardless of what the local inflation is. The total percentage cannot be increased above 10%. All right, so let me kind of make you understand what's going on, right? So for example, let's say that your local inflation rate is 4% where you're at, right? So the basis that you can actually increase your rent is that local inflation rate plus 5%, but you can't go over 10. So the local inflation rate is 4%. So when you add that to 5%, because we're trying to be reasonable, because you can only have a reasonable rent increase. So we're determining what is reasonable. So generally, reasonable, because you're looking at 5% plus the local inflation rate, but you can't go above 10. So if the local inflation rate is 4% and you add 5%, so that's 9%. So you're under 10%. That's okay. You can increase that rent by 9%. But let's say your local inflation rate is 6%. And let me tell you this, your local inflation rate changes every year. So for each year that you're looking to raise the rent, you better find out your local inflation rate. Let's say your local inflation rate is 6%, right? And you're adding 5% to that, that's 11%. You're not allowed to increase the rent past 10%. So even though when you add the local inflation rate to that 5% and it takes you to 11%, because you're capped out at 10%, you can't increase the rate past 10%, right? So always check your local inflation rate. And I think what may happen is, to be safe, you have to follow the rent standard. You can't just go and say, you know what, I can't bother find out what the local inflation rate is. I'm just going to increase this to 10%. No, you can't do that. Because if your local inflation rate was 3% and the only thing you can do is add 5%, then you are at 8%. You couldn't just go on your own to increase to 10. So what this imposes, we're looking at burdens now imposed on the landlord every year now. And the tenants are going to do this because guess what? They're on the receiving end of the increase. So what they're going to do every year, the tenant is going to check every year what is the local inflation rate, because you are now looking to impose an increase. But the law tells them it has to be a reasonable rent increase, and that reasonable rent increase is the local rent standard, which is whatever the inflation rate is for your area plus 5%. That's your standard. So every year you now have to check what is the local inflation rate. And in addition to that, you add the 5%, but you can't go above 10%. So if the tenant checks and realize, but wait, let's say the local inflation rate was 3.4%. And when they add 5% to that's 8.4%. So you're looking to increase by 10%. They don't have to pay you that, because you're going to get hit with, you have not abide by the local rent standard. So I want you to understand now, going forward as landlords, if you are subject to this good cause eviction law, you have to follow these rules. You don't follow these rules, your case is gonna get dismissed. You get stuck. Yeah? All right. So as of May 1st, 2024 for New York City, the inflation is 3.82%. So your local rent standard in New York City is 8.82%. So you cannot, right, raise the rent. If you are subject to the good cause eviction law, you cannot raise your rent past 8.82%, right? All right. So this took effect April 20th, 2024. All right. No matter what, how do you get past this? We have to be practical now. Everything has gone up for landlords. Your taxes have gone up, your insurance have gone up, your repairs cost has gone up. So now the burden rests on you, where you can actually show to the court, look, I have now faced this increase, right? And as a result of which I need to raise my rent more than this. So, one second. All right. Now, the court has a final decision on this. So because the court has a final decision on this, even though you have incurred this cost, if the court doesn't believe that your rent increase is reasonable, it's not going to make any sense, right? All right. Now, isn't this rough? How do you do this? For New Yorkers, now you're trying to find what's your increase just because, and I'm specifically gearing towards New York City, because wherever you live, you have to check the locality. For people who are in New York City, how you're finding what you should charge, multiply your current rent by 1.0882, right? That determines what increase, what the final figure for you should be. And it's rough because I don't know how they get the rate of inflation to be 3.82% for New York City. I remember when water used to cost 99 cents, that gallon bottle of water, you are now buying that gallon bottle ridiculously. What you're actually paying now is anywhere from, let's say, $2.50 to as much as $4 something. So how is the rate of inflation only 3.82%? Bear with me, Nicola just sent a question. All right, so this is coming from Tracy. It says, good morning, Miss Osbourne. If you're trying to add a case to your account, and when I'm trying to put in my online access code and date of birth, it is saying it does not match. What can I do? You have to reach out to USCIS. It's probably an issue on their end, or they probably have the wrong information somewhere. All right, so if you're just tuning in this morning, I had to focus on the good cause eviction law because it affects you whether or not you are a landlord or if you are a tenant, right? It has now created numerous defenses for tenants. It has now restricted landlords in their eviction process, but this is only if your premises is subject to the good cause of eviction. And I thought it was very important this morning to share this with you because a lot of people are not aware of this. They don't know whether or not they're subject to this. So we're going to look at homes that are exempt Good morning. If you're just joining, we're focusing on the good cause eviction this morning. And it's very important if you are a landlord or if you are a tenant and you're in a property where your landlord is in fact subject to the good cause of eviction. This took effect April 20th, right? And a lot of people are not aware that this has occurred. So this morning, I want to focus on it. If you are a tenant, this will empower you in your eviction proceedings. If you are a landlord, you are now going to get just an idea of some of the guidelines that you have to follow in evicting a tenant, and whether or not you're not subject to this, you still have certain rules now because of this statute that you have to follow. And I think as a landlord now, it's becoming tedious. I have clients who have decided, you see, what tenants don't understand is when they decide that they're not going to be paying their landlord, this now empowers the landlord to find the money. And what a lot of landlords have realized, not only the headache that comes with trying to evict a tenant, what a lot of landlords realize is that they can do this themselves. They don't need you. So because they don't need you, they're not putting their house back on the market for rent. If you are a tenant now and you're looking a place to rent, what you find is often when you go to the place or you call the landlord, it's gone because we have a crisis here in New York City. People are struggling to find houses, and these laws that they create, because one of the purpose of this law is to protect tenants. But who are you protecting? Where the landlords, especially the small landlords, are deciding that, guess what? I'm not renting now because I'm done with this. I have clients who have tenants. They haven't been paid in 5 years. And what I want landlords to understand is this is in fact a business relationship. These tenants are not your friends. So you can't go to the bank and say, I can't pay you this month because, I need to submit my mortgage payment, but my mom is ill. So I'm really not have the money to pay you this month. Nobody cares. It's a business relationship. So your personal problem, that's your problem, right? One of the first rules you should understand is you should protect. I don't know how you're raising your children, how you were raised, but one of the first things that you should know how to do is that you save your rent, you save your mortgage, because you have to cover the roof over your head. And I don't think a lot of people are understanding this concept. So they feel that their rent is not important. But what this is causing landlords to do is, my client who came to me and said for 5 years, one not paying, and then for 3 years because the tenants talk, right? So it's like, no, I'm not paying him. So guess what? They decide they're not going to pay you either. So, and you're living in the basement. So the tenants are living on your first and second floor, living nice, and you chuck up in the basement, but you're paying the entire mortgage because nobody's paying your rent. And this is what is happening now. And this is why this fuels our housing crisis, because it's hard to evict these tenants. Look at Brooklyn alone. Remember, if you're subject to the statutory termination periods. So now, if you have a tenant in your place for over 2 years, this is how ridiculous New York is. You have to give 90 days notice. So let's say you live in Brooklyn, you're filing in Brooklyn. You have to give 90 days. Having given the 90 days notice, you have to wait 5 months for a court appearance. So we're at approximately 8 months. Then after waiting that, having waited 5 months to get your date, and in total, because from start to finish, you're at 8 months. The first court date, you can't even discuss settlement because they get a free lawyer. So come back on your second court date that comes possibly 6 to 8 weeks away for you now to start discussing settlement if they want to settle. Because thanks to the budget planning in New York State, millions have been earmarked to provide tenants with free attorneys, right? All right. So we have this new law, right? The good cause eviction law. But certain homes are exempt, right? Because if your property falls within this, right? This doesn't apply to you. So, homes owned by a small landlord. If you are a small landlord, so that means someone who owns 10 units or less, then this doesn't apply to you, but I'm going to give you a drama now. What are 10 units? Let's say you own a 3-family home, and for this 3-family, each floor has 3 bedrooms. So you rent out the 3 rooms, right? Or probably you rent the living room. So if you have a 3-bedroom, that's not considered 3 units. If you probably rent the living room in addition to that, that's considered 4 units. So if each floor is rented, right? So we have 3, 3, 3, so that's 9. And let's say you rented the basement, guess what? That's now a 10 unit. But let's say you went and you rented the attic. So that's now 11 units. So now you are subject to this. All right. Now, if it is that you, in adding your units, let's say you had a 2-family, right? So that's 2 units. Let's say you owned enough property, and when you count each unit that you rent, and you have to count your illegal units, if you own 10 units, you're good. If you own 11 units, you're not good, right? So this is something that you have to know, because this governs whether or not you have the ability to evict without falling under this statute, because it's rough, right? Because remember, no, you have to have one of those reasons in order to evict. So a lot of people are going to be struggling to evict. This really empowers the tenants. And I think COVID, by its very nature, when the rules changed, had already given such a strength to tenants. People stopped paying. They don't care if they were making 6 figures. They weren't paying. They were protected, right? All right, because you had to prove. It's just ridiculous. All right, so let's say some buildings, as you know, some people put their homes under an LLC or a trust. Let's say you owned a house with other partners in the LLC. So you yourself, this building that's under the LLC, even though you're a part owner, you're not 100% owner. And let's say this building has 6 units, and then you have another building or 2 or 3 more buildings where they can add 10 units. So they're not counting the number of buildings, they are counting the units that's owned by you. So no one cares if you're a part owner or whether you're 100% owner. Once they can put ownership interest, and remember, you have to be careful, because now you're going to be signing the petition under penalties of perjury. So you don't want to get hit with a perjury charge, because you're in court now. And let's say you have a tenant who is a real investigator, right? And they realize that, no, this guy owns more than 10 units, because they go, and you'd be surprised when people need investigation, they're investigating you, they're gonna find out the information. So when they find that you own 10 units or more, you have a problem. 10 units is okay, 11 units plus is not. All right, so that's the units. Then we look to see whether or not you own 10 or more apartments, right? So if you have a building with 10 or fewer apartments and you live in that building, then that building is not going to be subject to this good cause eviction law. So we are looking at the number of units you have. Once it's 10 or less, you're fine, right? If you own a building where, and it's not just in that specific building, it's across the board. So you have to look at all the buildings you own. When you add up all your tenants, because each tenant constitutes a unit. I don't care if it's a room, I don't care if it's a floor. Once it can be considered a unit, whether it's 3 buildings, 4 buildings, you add, you get 10. You're fine. You add and you get 11, you're subject to the new law. It's a problem, right? So it's going to be rough, right? Now, if you claim, and here's now where I come into the whole invasion of privacy. Because let's say, thank God, this does not apply to you. I'm going to show you invasion now, because nothing is private anymore, right? So if you fall within the small landlord, thank God, you have 10 units or less across the board, regardless of the number of buildings you have, right? If it is that this statute does not apply to you because you have 10 units or less, you are now required to provide the tenant with a list of all of the homes that you own in New York State. So now your tenant is in your business because you want to be able to be exempt, because you fall in the exemption. So now you're not subject to this rule. You have to disclose to the tenant what buildings. You have to provide a list of the homes that you own in New York State. Now, if this is not a whole invasion of privacy, where now you have to provide your ownership interest in property, that's really none of the tenant's business. But because you want to say that this statute does not apply to me, your business is now the tenant's business, because the tenant is now privy to property that you own, because you have to list it. You have to provide the tenant with the list of all the properties that you own. This is madness. So where's the privacy anymore? It's ridiculous, right? But the only good thing is you don't have to provide the tenant with your primary residence in the list, right? Because, and I'm glad that somebody had the sense to realize that some of these tenants, I've had landlords who have been stabbed, who have been spat on. There has been some form of physical confrontation. If you have one of these tenants, right, and they also become aware of where you live, it can get dangerous for you. And this is why now, if for the property that you own, you don't have to list that property if it's your primary residence, right? Okay. Buildings with 10 or fewer apartments, if the owner lives in that building, you are not subject to this good cause eviction law. Now, we're focusing now on homes that are exempt. So if you are a landlord and you own 10 or fewer units, you're not subject to this law. If you have buildings with 10 or fewer apartments, and if you live in that building, you're not that. If you're evicting somebody from that building where you live and it's 10 or fewer apartments, guess what? You're not subject to the good cause eviction law, right? Now, if the tenant sublets the apartment and the main tenant wants to come back, then you're not subject to the good cause eviction law. You can now evict the subtenant without the fear that you have to follow the rules of this good cause eviction law. If the tenant got the property as part of their employment and you now want to, let's say you terminated that employee, you want back your place, you're not subject to the good cause eviction, right? Homes which are regulated by federal, state, or local government, right? So, for example, homes in the NYCHA public housing, homes with project-based Section 8 vouchers, or homes that's rented through, HPD, Housing Preservation Department, you're not subject to the good cause eviction law. So, you know what I see in this madness is that you're now encouraged, because you don't want the hassle, you're now going to be encouraged to take Section 8 tenants here. Now they have a greater protection because you as a landlord, you're not subject to the good cause eviction law if you are renting to a Section 8 tenant, or you get a rent subsidy from HPD. This is so unfair here, right? All right, so just tuning, just joining in, we're now focusing on the homes that are exempt. And I'm just going to go into detail just before I just give a little synopsis of it. I find this statute, once again, New York has always been in my opinion, an anti-landlord state. And this is proof. Yeah, I can't give you any other. This is proof of it. All right, if your home is a condo or co-op, it is not subject to it. Homes that are built on or after January 1st, 2009, you are not subject to the good cause eviction law. Homes that qualify for seasonal use, homes in a hospital, a continued care retirement community, assisted living facilities, adult care facilities, senior residential community that is a condo or a co-op, or a non-for-profit independent retirement community that offers certain services to residents, then you are not subject to this good cause eviction. If it is a mobile home, if you're in New York City, have you ever seen any mobile homes? All right, hotel rooms, dormitories owned by a higher education institution or K through 12. So when your kids go away to school and they're taking up the college campuses, I've never lived in campus housing. I've had friends that lived in campus housing. But if your kids are in campus housing, the good cause eviction does not apply to them. Yeah. So they can get their 30, 60, 90-day eviction. Home used by religious facilities. Well, thank God the church get a little blessing, right? They are not subject to this. No. And this is where our quote unquote 1% people benefit from the rule. If it is homes that rent for 245% of the fair market rent, right? And that's determined by the US Department of Housing and Urban Development, what we know simply as HUD. These people get protected. So I'll show you what that rent looks like. These people are not touched. This is where our 1% elite, right? This law doesn't touch them. So if you rent your studio, and where is this going? Other probably the Hamptons or Manhattan or certain areas. If the rent for the studio is $5,486 per month, good cause eviction, don't touch those people. If the one bedroom is rented for $6,005 per month or more, this new statute, the good cause eviction, doesn't touch them. 2 bedrooms that are rented for $6,742 or up, 3 bedrooms that are rented for $8,413 and up, and 4 bedrooms that are rented for $9,065 per month and up. This new statute does not apply to them. Good cause for who? Not the landlord. Yeah. All right. So it is what it is. One thing I want you to always bear in mind, to be exempt from this, you have to be able to be a landlord. I remember you're putting this under perjury on your petitions. You have to fall within one of the exemptions. You have to state why it is that you're exempted from the good cause eviction law. You can't just evict without adhering to those rules. One of the things that most small landlords are going to fall in is that they basically have 10 units or less renting, or that they have 10 or less buildings, or the 10 or less unit, they actually reside in the property. This is not going to be hell, yeah, to evict the tenant. I want you to understand the frustration as a landlord, where even though you're not even subject to this, you now have to report to your tenant all the properties that you own in New York State. You know, I have a girlfriend that she says she's done buying property here. She's going to Pennsylvania because people are tired. They're frustrated with the rules that you have here. Any day you have off, right? Because housing court is a public court. You can't just walk and you can sit in. I want you to have a day off. You have nothing to do. You just want to burn time just to see the madness. You're going to hear people waiving rent 3 years, 4 years, yeah? Because I want to get the tenant out. On average, you're pushing for a trial. What? You're going to take like a year and a half to get rid of this tenant, even more? Some people are at their wits' end just to get back the place. That's what is more important to them. So just to recap quickly, we're coming to that time as to if you as a landlord, you can get exempted from this. So homes that are owned by a small landlord, so someone who owns 10 units or less, right? Buildings with 10 or fewer apartments once the owner lives there, right? If the tenant sublets and the main tenant wants to come back for the place to return to live, you're not subject. So we're just going down who as a landlord is not subject to this new good cause eviction statute. If the apartment, you received it as part of your employment and you're no longer employed there, the landlord is not subject to this, right? Homes that are regulated by federal, state, or local laws, or if the tenant rent is paid by NYCHA, HPD, any Section 8 based tenant, you're not subject to this. Homes built on or after January 1st, 2009, homes that are used for seasonal use, homes in a hospital or retirement, assisted living, or senior residential community. Co-ops and condos are not subject to this. Manufactured or mobile homes, hotel rooms, dormitories for school purposes, higher education, or K through 12. So those dorms are not subject to the good cause eviction. Homes are within and used by religious facilities, and homes that rent for greater than 245% of the fair market rent. So welcome to hell. That's that's the only thing I can tell you. Landlords in New York, especially New York City, because if you live in a town that really decides that they are not going to opt into these rules for the good cause eviction, you're good, right? But once they opt into it, even if you're not subject to the rules, now the tenant is in your business. Complete madness. But welcome to New York City and welcome to New York. You never know what they're coming next to be a landlord's worst nightmare. All right, so thank you for tuning in. We should be back again next Sunday. Enjoy the rest of your afternoon, and I'll see you next week, Sunday. I'll try and post the lives earlier so you know the time, probably a few days before today. Yeah. All right. Enjoy your Sunday. Live good. Stay good with your family. Take care. See you next week.